Hello, I'm Brian Lucareli, Director of our Private Client Services Group and co-chair of our Family Offices team at Foley and Lardner. And today I'm here with Jason Kohout, a partner and co-chair of our Family Offices team. Jason, welcome back to the interview series.
Hi, Brian. Glad to be here.
Good. And before we get started though, Jason, can you just remind the audience a little bit of your professional background and then we'll jump right into it?
Sure. So here at Foley, I'm the chair of the Family Office project. I also am a estate and trust planner and do a fair amount of work in the charitable giving space.
Great. So Jason, you recently spoke at the 2023 Family Office and Wealth Advisor Forum hosted by Family Office Exchanger Fox. And your panel addressed how to navigate key challenges and opportunities for clients presented by the recent and potential income tax, trust, and estate planning laws, regulations, and cases. Now, that's a big mouthful there.
That's
But
right.
during this session, we wanted to talk about, can you talk about some of the highlights from your panel?
Well, I can talk about the highlights. That's right. And I will say, Brian, it turns out that was a mouthful. We had less to talk about than in some years because right now it appears that Congress is not going to be agreeing on anything. That's, as we all know, that's at a pretty big premium in Washington right now. So when we look at legislative changes, some of the things that we talked about in 2021, we don't really see that being, in the immediate foreseeable future, right? In the next 2 or 3 years. Of course, after a presidential election and an election, that could all be very different. But today we don't see much in the way of changes. It came up at the event, and I always like to point out that we've looked at the prior changes and the prior proposed changes, and there have been slews of them. The proposed legislation has been written and circulated in many different cases. I have not seen an instance in which doing planning today, doing the kinds of planning that we are all familiar with, like installment sales and grats, that if you did that planning today, you'd actually be worse off in the future. Now, it's true that planning may not be as effective if some of the proposed changes that we talk about, like limiting grantor trusts and grats and that sort of thing. It may not be as effective in the future as it is today, but I haven't seen a situation in which you'd be worse off. So we are telling people, or at least that was the conclusion me and my co-speaker made, was that, look, it's probably best to be thinking about moving ahead before the magic date. So the magic date in estate planning is December 31st, 2025. That's when, how should we say it? The bell tolls for Cinderella, and the amount of bonus exemption is gone. So to the extent that you're thinking about moving ahead with things, I think you would want to do that, even though there is not going to be, hopefully the end of this year, there won't be a huge impetus to do so. There won't be a move it or lose it type operation.
So with that December 31st, 2025 date etched in stone and thinking about planning, what else should people be keeping in mind?
Well, it is important to remember when it comes to Congress, it's all in pencil, or at least in ink that they can amend and change. But we just don't know. We just don't think that would be the case. We'll see, depending on what happens in the election. But when we talk about what people should be thinking about, keeping in mind, the things that did change in estate planning, I think in the last year and a half, would be that the interest rate changed. We all know this, of course. Everybody knows that the interest rate went up. It's just that for many of the techniques that we use, the interest rate is a key driver. So 2 or 3 years ago, we were doing installment sales at 1 or 2%, right? And it was an incredibly good time to be planning. Now the interest rate is up to 4% or 5%, right? And all of a sudden that planning can be very effective. It's just that it is not as effective as it used to be because the interest rates went up. Now, there are certain aspects of estate planning that do become more relevant when the interest rate goes up. That would be qualified personal residence trusts. And I think already I've seen 2 or 3 clients focused on doing a CUPER this year because those actually, they look better. They will be more effective at estate planning. And then also CRUTs. So to the extent that you have appreciated securities and you want to shelter some of the gain or defer some of the gain, you want to diversify, shelter some of the gain, and there's a concept of a real charitable purpose that the client wants to do something charitable, CRTs, charitable remainder trusts, can look better. And then lastly, the thing that strikes me, and this did come up in the some recent legislation, right, is that the IRS is being funded, so they are getting up to speed, and they will have more agents. I think we've all heard about that. And at some point, we talked a little bit about this in our presentation. There have been green shoots of the IRS being more responsive, and they have been clearing the docket a little bit more quickly. I think you'll probably continue to see that, and over time, the IRS will have more resources to do more audits, to do more examinations, and so, to the extent that that happens, we will be in a little bit different boat. I think there's been a fair amount of the IRS does not have the resources, and we all know that, so that they haven't been looking at everything as closely as perhaps they would like. So that will be a slow change, but it will happen. In the recent legislation, though, to get past the debt ceiling, the Republican Congress and President Biden agreed that some of the funds that were earmarked for the IRS will not be earmarked for the IRS. I don't think that'll have an appreciable difference in what we see, but we'll see.
Okay. And then, so what else is going on in Washington? What else is on people's minds?
Yeah, I can tell you from that conference, and I bet it's the case at every family office I know of. It's the case at our law firm, right? The thing that people are really worried about is the Corporate Transparency Act, right? And they should be. They should be. Brian, you and I are going to be talking to our paralegals internally about all the entities, every entity that filed a document with the state to be created, except exempt organizations, my specialty, but private foundations don't need to file, but pretty much every entity that we've created, and we create quite a few of them in estate planning, is going to need to file. It's going to need to file its beneficial ownership by the end of 2024. So
Okay.
when the calendar turns, you'll have 30 days. You create a new organization next year, you'll have 30 days to file, and then you have all of next year to file. The issue is going to be just getting all the filings done, and we're not exactly certain what the form looks like. The one proactive thing that I was talking with my co-presenter, the one thing that we thought maybe of some use would be going to go get EINs for single member LLCs. Many times we don't go get EINs for single member LLCs. And would it be possible, and you may not know this, but you can only get one EIN a day with a Social Security number. So would it be, that's nitty gritty, but would it make sense to start going to go get EINs? There are family offices out there. I'm sure everybody's aware. I mean, they have many entities, and this is going to be a big issue. So it's just like us at the law firm, Brian, we're going to start collecting information to get prepared. But other than that, that's what everybody's thinking about. Unfortunately, we have very little in the way of, answers for what to do about it, but it's coming.
So, well, that's a great planning tip, just about EINs and when to start doing them. And then, lastly, I'll just kind of wrap up. Any other interesting highlights from your panel?
Yeah, it was like the potpourri round on Jeopardy, Brian. There were cases. Some of them are very interesting. Some of them are a little, they make you think, boy, did I do something like that and possibly get in trouble with the IRS? But the interesting ones where there's a new case on adequate disclosure, and turns out it's pro-taxpayer, which is great. Adequate disclosure is what we talk about whenever we make a gift. We file a gift tax return. Everybody tells the clients, file this gift tax return. You'll start the statute of limitations running if you adequately disclose. And we all plead to say, hey, get more information. Make sure we have a very good appraisal, right? And it turned out for the taxpayer here, it worked. His actually adequate disclosure, which everybody should read the case, Schleifer, it wasn't exactly perfect, but it was sufficient for statute of limitations purposes. So that was a very positive development. And again, it gives a little bit more substance to all the work that tax return preparers that we're doing at the law firm and people at family offices are doing, because that's a pretty important thing. And it's good to see that it worked. And then we talked a little bit about the Patagonia structure. So that's the use of a 501c4. And then lastly, there's a negative case out there. Somebody was a little too aggressive on, it's actually a CCA, but the IRS is taking the position when you're a little too aggressive on using a low appraisal for stock and then funding a grant, that you may have problems with the IRS. So the IRS is taking a negative approach in the set of facts there. It is probably something to be aware of and certainly to take a look at.
Well, Jason, as always, I want to thank you for jumping on the interview here and sharing your insights from your recent panel. And again, I want to thank all of you for watching our presentation. For more information, please visit us at foley.com under Family Offices. Thank you.